Well, after the government rests its case, you typically have a motion for ruling as a matter of law that the evidence is insufficient to meet the allegations that are laid out. What is atypical is to have the jury rule on the motion, but this is an impeachment trial, not a criminal trial.
This is a democracy. So they're going to vote. It takes a majority vote. They said they will have some of the votes singularly on the 16 articles and some grouped together. So apparently it will take several votes to get through this.
So that'll give us some sense of where people are, right?
It should.
Or will people hedge their bets? I don't know. I mean, this is just a crazy situation because it was clearly so unexpected what Rusty just did here. He did not mean to rest.
No, he did not. He meant to pass the witness, not to rest the case.
What did you think about the way that Busby handled it?
I think the way he handled it demonstrates, it either demonstrates confidence in where the defense is with their case, or he was trying to project the confidence to the senators that what you just heard was throughout the entirety of these proceedings was such a non-event, I'm not even going to cross-examine this witness.
Yeah. It was, it really, when he said he rested it, I was like, he did what? It really caught me flat-footed.
Right.
And then, go ahead.
It caught Busby the same way, I think. And he said almost in the same breath that he reserved the right to recall the witness, but we are submitting motions to dismiss the articles.
Right.
Which typically does happen after, in a criminal trial. In a criminal trial, that's actually pretty typical, where the moment the prosecution rests, you ask for a directed verdict. So that's what's happening here. It's just the difference is you don't normally have the jurors vote on the directed, vote on the motion.
That's
That's
exactly
just
right.
a very unheard of, rare situation. And you can see a live look there in the Senate chambers, various senators, talking, and I don't know, of course we have no idea what the conversation is there.
Well, Senator Birdwell in the middle is trying to explain what the rules will be. I'm sure they want to know whether debate will be allowed, whether questions will be allowed. I'm sure the senators are asking, how much input they'll have or not have, and whether they'll even be able to identify which article is which. Are they going to read them off, say Articles 2, 5, and 7? What are they? Will they know what they're voting on when they're voting?
Well, because they're probably also a little bit surprised right now.
Right.
Because, again, Rusty Hardin clearly did not intend to rest.
That's right. That's right.
Obviously he is considered a legal legend, but what I've seen in this trial, I've seen a lot of missteps. Just in terms of management of the clock, and Aaron Epley today was stellar.
Yeah,
Absolutely
I thought she
stellar.
did a very effective job.
And so it just, I don't know. I don't know the reasons why or what, and maybe the approach of the way he normally handles cases works in other venues, but it didn't feel like it worked here.
Well, this was sloppy, but he would have rested after the cross-exam anyway, right? So was this really that much of it was off note and threw everybody off, but was it ultimately that different? He would have rested after the cross-exam, and then we'd still have these motions.
Except it gives the opportunity for Busby to grandstand, which
is exactly what he did. He seized on it.
Projected in a confident manner that I don't even need to cross-examine this witness. You rested. Let's just move towards throwing out these bogus charges.
Let's throw it all out, y'all. Come on, y'all. Let's all go home.
And Busby's a showman, and he showed right there that he can seize on any misstep and turn it to his advantage.
And that's exactly what he has done here. So what we're doing, what we're waiting on here right now is, and you can see Angela Paxton actually kind of coming up to the group. But they've the defense is making a number of motions for a directed verdict to seek to throw some or all. I guess they're probably going to have probably kind of similar to what they had at the beginning of the trial. There was one that sought to throw out all of them all at once, and then they had them, grouped. And wouldn't be surprising if it's similar in terms of what we saw before.
Right.
And at the beginning of the trial, the votes were from 22-8 to 24-6 to proceed with various articles of the trial. There were some that were questioned. The one about the special prosecutor was the one that was the least popular.
And go ahead.
The important thing about this is that it'll take 16 votes to throw out an article. If it's tied 15-15, then the motion fails. Mm-hmm. So it'll take 16 votes to throw out any of the articles. When we get around to another vote, if it were in favor of the prosecution, then it would go the other way.
Which of the articles?
Teresa live at the Capitol.
Okay, you want to bring Teresa in? Okay, so we got our colleague Teresa Woodard, who's at the Capitol. We're going to bring her in on a video call to see what she has to say, because she's obviously there on the ground in Austin.
Hi. Yeah. So what a wild development
Hey,
this
Teresa.
afternoon.
I can't,
hi.
hold on,
Can you see me?
I
Can you
cannot hear
me?
her under my ear.
Can't hear me?
Can't hear.
Nobody
Hold on,
can hear
he's
me?
fixing it. Jay is fixing it.
Okay.
There, now
There she
you're in
is.
my ear. Wow, the magic of technology. Okay.
Can you hear me now?
Well, I can hear you now. Okay, Teresa, go ahead.
Okay, very good. Hi. Yeah, so what a wild turn of events. Just in the last episode, we had news that the alleged mistress, Laura Olson, we all expected her to take the stand late this afternoon. Then we got word she had been deemed unavailable to testify. We were seeking some clarity on exactly what that means, and maybe your experts there at the station could lend a little bit more shed a little bit more light on that, because it's unclear to us if that means unavailable to testify means for the duration of the trial or if it just means for today. But of course, the thing that is happening right now was that accidental rest. I think that was a very wild development that no one expected to happen. And now we're going to wait and see how this is going to go down as they ask for that directed judgment. It's not surprising that they would do that. Like you've been saying, we hear about a summary judgment in most trials, and so you would certainly expect this to happen. But what will the vote be? That's going to be key. And as you said, I think it's going to really sort of give us an indication of where things stand. Are we moving forward, or have we heard enough? Is it over?
How surprised were you, Teresa, that we suddenly didn't hear from Laura Olson after we spent all day, all of us waiting all day long, and then it didn't happen?
Yeah, that appeared to be the most stunning item of the day until the accidental rest from Rusty Harden kind of overshadowed it in the last few minutes. Yeah, our colleague Jason Wheeler happened to be out in the hallway, and he saw Laura Olson headed for the exit of the Capitol. And then I saw from another photographer who was stationed outside of the Capitol that she had left the grounds. And so that was definitely a surprise. It was unclear to us exactly whether, right at 4 o'clock, if we were going to see her take the stand. But we did know that her attorneys were trying, it appeared, to keep her from having to testify. And so, it was still very surprising that was where it seemed like everything was headed. And then suddenly it didn't happen.
Yeah, we were certainly shocked when Dan Patrick said that she was present but deemed unavailable to testify, because at first we were like, okay, is that just today, or is that it?
Right. And so what are your experts there? Can we get some clarity? Because as I said, we've been trying to get some clarity from our perspective, but what does that exactly mean? That's one thing I need explained to me. What does unavailable to testify mean? Does that mean for the duration of the trial? And why would that happen?
So first of all, it's unprecedented. I've never seen a circumstance like this. One of the senators, I don't know who it was, asked for clarification.
Yeah.
And you'll recall that Lieutenant Governor Patrick said that's the agreed statement that the parties worked out, and that's as much as I can tell you. So I'm at the same place the senators were. The statement is a pretty bland and general statement that, if you take it on its face, means that she's not going to testify at all, because there's no temporal limitation on, quote, unavailable to testify.
Well, and now that the House has rested, presumably the defense is not going to call her. So it seems like we're not going to hear from Laura Olson in this trial.
That's right.
So, I mean,
Which is shocking.
It is shocking because there were things she could answer.
Well, Victor, we were asking if she decided to take the Fifth Amendment. Well, we don't know this, but there's some suggestion that maybe she decided to take a Fifth Amendment. Why would they not want that announced to the jury? Is there a reason that either side would not want the jury to know that?
Well, the defense would not want the assertion of the Fifth in connection with questions that are connected to Attorney General Paxton. On the flip side, you would think that the House managers would want that. So I wish I was a fly on the wall for the discussions about her testifying and her attorneys not wanting the testimony to happen, to see how that agreement was brokered, where we get this bland statement, quote, present and deemed unavailable to testify.
Now Elvis has left the building.
Yeah,
I mean,
it appears that way.
Yeah, it's pretty stunning. Hey, Ryan, will you send me that story you're talking about?
It's just a tweet.
That's a tweet. Okay.
They're just taking a break so the jurors can meet.
Oh, okay.
Discuss
So
what specifically that's kind of what's going on.
yeah, the Texas Tribune is reporting that that there's a break for the senators to meet, and that seems to be what's happening. Of course, everything's in flux.
I glanced.
Go ahead.
We saw on the camera, we saw them gathered around
Glancing
Senator
down,
Birdwell.
exactly.
Yeah,
I
Senator
glanced
Birdwell
down and
chaired
the
the rules.
stream
Go
had
ahead.
stopped, and you don't quite know exactly what's going on. But
back into the house.
okay, the House Board of Managers.
Yeah,
Okay, so I'm told by our esteemed photographer, Martin DePorto, who's been down here covering the duration of this, that the House Board of Managers just walked from the Senate chambers back into the House, and so they've left the chamber. And so, as you said, that would make sense if the jurors are taking a break and they're going to discuss. They probably are in the same boat we are, that everybody's flying by the seat of their pants. Nobody really understands exactly how this whole thing goes down. So perhaps it's a good thing to take a breath and try to better understand exactly what the rules say and exactly how this is going to happen.
Well, it felt like we've had a lot of surprises. First of all, this morning we thought we were going to get Laura Olson, then we didn't get Laura Olson, then when we thought we were going to get Laura Olson, then we didn't, and then Rusty clearly mistakenly rested. So it was just really, shocking kind of all the way around, and I guess everybody's kind of caught flat-footed here at the moment.
But
Right.
now these motions are not a surprise, and as you said, Victor, I mean, this is customary at the end of testimony for the defense to move for summary judgment.
Yeah, whether it's a civil case or a criminal case, the party with the burden of proof has to sustain their burden, and if they don't, you typically see a motion after the close of evidence.
Okay, so we're going to let Teresa Woodard go. Teresa, thank you so much. It's good to see you.
Thank you, guys.
Appreciate
Thank
it.
you. Good to see you all, too.
Thank you. Okay. All right. So we're just kind of back to tap dancing again here.
That's right.
Just like, okay.
Well, the jury has to figure out what they're doing and how. Chairman Birdwell seems to be acting as sort of a de facto jury foreman, since he chaired the committee making the rules.
Right. We
And
see
so-
them all kind of talking there in the House. They've got a computer out in the. You think they're reviewing the rules? Is that what we think's happening?
They
right now?
may be reviewing the rules, or they may be reviewing the articles. I mean, we don't know for sure, exactly how these articles are going to be presented for them to vote on. Whether they're going to have to review which one is which, and go back through their notes and consider, how they feel about each one. We don't know how they'll be presented or how much time they'll have. So, those are things that they're working out. Senator Birdwell, of course, is from Granbury, serves a Senate district that represents mainly Waco, but stretches up into Mansfield and the southern DFW area. He was the chairman of the committee that wrote the rules for the trial. He also, this week, he was remembered as a survivor of 9/11 in the Pentagon. And so he was burned severely in the Pentagon and survived the attack on the Pentagon. And so he is, this has been a week of when thoughts were with him in many ways. He's on the spot here.
Yeah, no, this is all very fascinating, and I guess it'll be a little bit like we saw on the first day, where they'll vote on each of these motions and they'll read out each senator's name, right? I mean, that kind of feels like that's what's going to happen.
Roll call.
But this is these articles are separate, and what they said was that they would group some articles and then have others individually. I assume that they'll group the articles. I'm really guessing about this. I don't know at all. I assume they'll group the articles relating to to any sort of bribery, and then they'll separate out articles related to the mishandling of the alleged mishandling of the open meetings law and some of the other articles that you could make a separate debate, have a separate debate about.
Brickman's testimony up until all this happened was up until we kind of got in this thing about can we get this report in or that reporting in, was actually kind of effective testimony. And it feels like it's kind of lost in here.
It was very interesting for sure. It's akin to driving 90 miles an hour and then all of a sudden at the end coming to a screeching halt is kind of the analogy I would use.
Yeah, it was, all of a sudden we've had this whole day where we thought certain things were going to happen and then they didn't happen, and then something that we didn't expect, which is Rusty resting the way he did, and then now everybody's just kind of, flat-footed trying to figure out, I guess, what do we do?
Right.
But how, in your mind, Bud, how much do you think the votes here on these different motions will telegraph how people are going to fall on the final motions?
Well, theoretically, you would say that the senators will vote on whether they want to continue the trial and hear the closing arguments, whether they're ready to make a decision or not. That's theoretically the way they would vote. But in actuality, I think that many of them had made up their mind before the trial. A couple more may have made up their mind since then. And generally, I think that we're going to know from these votes how much further they want to go. I think what they've done is given them a chance to go home if they want to go home, and it is so they're going to have to make the case for continuing the trial. They had the opportunity to go home at the beginning of the trial, and only from 6 to 8 of them wanted to go home. There were 22 to 24 who wanted to stay and have a trial. So we'll see how many want to continue.
So at 5:45 p.m., Ken Paxton tweeted, "I'm heading to Maine next week to sit down with Tucker Carlson and discuss the last 2 weeks in Texas politics. It should be interesting." So that was about 4 minutes ago.
Yeah, well, that fits the political, the kind of the team the team patriot that has been arguing Paxton's side all along.
You think they'll argue the motion on, while we're at it, you think they'll argue the motion from the House Board of Managers about combining the two votes? I mean, it seems like they would go ahead and do all of those, right?
You would think so.
And that can't be argued until tomorrow under the rules. And I'm sure the House Board will want to say, wait a minute, we have a motion that we want to make that we can't make till tomorrow. You can't stop the trial now without debating our motion. But that this vote may make that vote moot.
It could. I mean, do you think that's likely?
I don't think so. I mean, I would think at this point that there would be 16 senators who would want to proceed with at least one of these articles. I think that some of these articles were not well phrased, well cast to begin with, and they may eliminate some of these articles, but I think that there are a few that the senators will want to continue with.
Do you think Bud, do you think they moved too fast? Should they have done a better job wording these articles?
I think that it's obvious in some of the cases. The case in the article involving the special prosecutor, for example, it calls him a special prosecutor, but the defense says he wasn't really a special prosecutor. They called him by that term, but legally this was his status, and so that article's not valid because that really wasn't what he was, and things like that. I think that the writing in some of the articles of impeachment has been imprecise, and the defense has taken advantage of it. I'm not sure that they moved too fast. I think that they were trying to string together a lot of threads and tie the bow together. And I'm not sure. Some of those were vague for a reason, and you felt like that they were going to come to court and explain all this, and they explained some of them fairly well, and some of them they didn't explain very well.
Did they tie the bow together, Victor?
Well, if you look at the reaction from Busby when Hardin accidentally rested, you would think that they didn't tie it together. But it ultimately is going to rest in the hands of the senators, and it's anybody's guess.
I mean,
Yeah.
you still get back to the questions about bribery, which are, if this was bribery, what did he get? Who got anything for it? He didn't get a new kitchen. What did he get? And so, are the bribery, articles valid? Of course, it was certainly the prosecution proved that there were attempts and discussions that headed that way, which are enough to uphold an impeachment article.
Well, there is an impeachment article on attempted conspiracy.
Right, and there's enough to sustain an impeachment article on attempts. So it's how each article is worded.
Is it usually better, and I understand this is not a criminal case, we have to be careful about that, but is it usually better in your experience when you're trying a case to take a more focused approach? In other words, to try to, I remember one of my colleagues years ago covered the Holy Land Foundation case. And the first trial ended in a hung jury. They kind of threw everything up against the wall, and then they came back the second time and they won, but they had a much more focused, narrative that they told the jury. Would that have been more effective in this?
So when you have a complex case, it's always the challenge is how do you make something that's complex, unified and streamlined. I love, I'm a reader, and I love reading Stephen King novels. Anybody who reads his novels know that they're very lengthy, but typically he has one or two or three things that he'll string through the entire book, and that's what happens. Like in the Holy Land case, you might have a very complicated story, but if you can string it together with a few simple things that tie everything together, it's much more effective than throwing a bunch of things against the wall.
All right, we got to fix Victor's mic. It has died, guys. This is what happens when we're up here all
Battery
day
swap.
long, all day. Sorry, guys. We're gonna fix Victor's mic.
We see no jurors now. We
got a live look there in the
with
Senate
their
chambers.
discussion. They've left the room.
I think it feels like, I don't know. This is kind of crazy.
Thank you.
There you go.
Perfect.
Well, okay,
It's
sorry
kind of
about
like
that,
it's
guys.
kind of like a pit stop.
Look, I understand you guys are complaining about the audio. This is what happens when you've got people who are up here all day long, and we have to kind of and I've been keeping an eye on mine. I still got 2 hours left on my mic. Okay, start that over, because they didn't hear you.
Yeah.
So I think the question was, what do you do in a complex case where you have a lot of information? Here you have a lot of allegations and articles of impeachment. What you want to do as a trial lawyer is to have a unified story or theme so that you're tying everything together and keeping it focused rather than having a bunch of things that you're throwing against the wall and taking a more scattershot approach, which really knocks your ability to be persuasive.
Yeah, and that's just, it feels like to me they were trying to do too many things all at once. And I mean, of course, we don't know how this is going to turn out, but when you have time limitations, telling a focused narrative is really important.
It's critical. It's critical, but it's critical when you have time limitations. But even when you don't have time limitations, people's attention spans are not very long, and you want to have maximum impact. So you got to tell a tight story with really focused themes and write that in a very focused manner.
Hey Jay, can you put up the live look in the Senate chamber real quick? So we can kind of, I mean, so folks are asking if you, there it is. You can see pretty much, well, there's still a few senators in there, but you can see the House Board of Managers over there in the corner. You see Rusty Hardin and the rest of them. Dan Patrick's not in the room. I don't see Busby anymore, but, or maybe that's him off on the side. It's hard to tell, but I mean, it just feels like everybody's trying to figure out what to do.
You know, I think for the Ken Paxton devotees who are watching or commenting, the fact that we're already talking about how Rusty Hardin mishandled time and mishandled the closing and mishandled everything, generally, and I think that other people are commenting too about Rusty Hardin's handling of the prosecution. I think that means that people generally feel like the prosecution hasn't totally done their job, and they had 16 bites at the apple on this. We'll see whether they were able to bring home any of the 16.
I mean, I think that there was certainly a lot of really troubling things testified to in this trial. And again, all of these whistleblowers, these are all handpicked Ken Paxton people who, to a person, testified about this series of interactions they had that involved the way that the office was handling Nate Paul. Now, whether or not the senators decide that that makes Ken Paxton unfit for office is a separate matter, but it's still troubling. I still don't think you want the Attorney General of Texas acting that way on behalf of one citizen of the state of Texas.
Well, that's the basis of the articles. Ultimately, we'll see if the senators think that's the case.
Right, and again, that's up to the senators, but you just have to question a lot of what was happening. You have, the hiring of Brandon Kamek, this attorney who has no experience, he's never been a prosecutor, he has no experience in public corruption, and he's never so much as done a subpoena up until that point. And, you put him in charge of this investigation, and he's relying on Michael Wynn, who's representing Nate Paul, to kind of direct him in what to do, which is just,
it's shocking.
It is shocking.
If you're one of the senators out there who's up for re-election, who's in the primary in the spring, who's on the general election ballot in the fall, has the prosecution given you enough to go back to your voters and say, well, there was a reason that I supported, that I wanted to sustain the articles of impeachment. I think I think some of the senators who are in the middle may, it's a little tougher for them to go back to their voters and say, well, I thought the prosecution was right on.
Well, I think overall, I've watched the trial, and it seems like the defense in some areas outlawyered the prosecution.
Certainly, we saw that today from a procedural standpoint.
Certainly Tony Busby with his using of the prosecution's time and his constant objections, and then Mitch Little was very effective. I thought the defense team had some talent and had the touch that Tony Busby's famous for.
Well, I think if we had seen a lot more of Aaron Epley in this trial.
Well, I was going to say that to me, if we're picking stars for the day for both sides, regardless of what people think about Busby's tactics, what he did was very effective in breaking up the flow of the House manager's case. But on the other side, the star would have been Aaron Epley for sure. She was very effective, particularly when she came back in a fiery, passionate manner on redirect.
Oh, yeah, she was really good.
Yeah, she was on fire doing that redirect examination. And she was making a lot of good rhetorical points, some of which she knew would be objectionable. And she was using her rhetoric as opposed to the answer to make her point. She was very effective in that regard.
It wouldn't surprise me if they don't come back and say we're wrapping up for the day. Well, it kind of seems to be the par for the course.
I think that's very likely. They say, okay, we've talked enough, and we're coming back tomorrow to take up these motions, because they'll require, how many? Not 16, but probably 12 individual votes of 30 people standing up a piece, and voting yea or nay. So that's going to be a couple of hours to deal with.
So Aaron Orner's asking, do the experts on the see this motion as a way for the defense to get a jury poll before starting their case?
Well, you typically see a motion like this in every trial, but I think in this instance it definitely is a way to poll where you are to see where things stand between you and the jurors.
It's a motion to give the Senate a chance to go home if they want to go home. It's a motion to end the trial right here if the Senate so chooses, and it's not just polling. It's say, okay, y'all, we could wrap it up now if you want to, and I think that there were only 6 to 8 senators who wanted to wrap it up at the beginning of the trial, and we'll see if that number's changed.
Yeah, and I guess the question is, are we going to see that, today, or are we going to see that tomorrow morning? Is this actually going to,
It takes 16 to pass a motion, so Paxton the defense would have to pick up 8 to 10 more senators over what they had at the beginning of the trial. That would be a pretty substantial swing in the jury.
That's right.
So somebody's asking if Rusty accidentally rested. I think it's very obvious
Yeah,
he
that was-
accidentally
I think he said
rested.
he did.
Yeah,
Yeah.
it was. He was. So there is a procedure in courts allowing the opportunity to reopen, which is a discretionary call. I'm surprised that Rusty didn't pull that out of his pocket and say, "Well,
say
I
what
moved a motion to reopen."
Oh, okay.
So it's an accident. I didn't mean to do it. Move to reopen. To give the other side the opportunity to cross-examine. I don't know that such a motion would have changed the result because Busby was there saying, I'm willing to forego my cross-examination. Let's get to what I really want to get to, which is throwing out these charges.
Right. Yeah, you think he should have done that? You think he should have?
Well, I mean, it was an option. Whether he should have done it, I don't think, whether he did do it, I don't think it would have made a difference. I think the result would have been the same. The lieutenant governor probably would have said, well, you're moving to reopen in the face of Mr. Busby saying he's willing to forego cross-examination, so I'm not going to deny your motion and let your resting stand, and let's move on.
Yeah.
If I'm Tony Busby, I want to go ahead and have a vote tonight when everybody's tired and may want to go home. If they take the night off and go home and rest, they may come back in the morning and say, let's continue this trial and let's listen to the closing arguments as long as we're here.
That's right.
Yeah. I mean, but I would say that just the way that we've had these things the last few nights where they tend to go out and do this, usually they come back out after a while and just say, see you at 9 o'clock tomorrow morning.
That's true. It's very possible.
So then, and this vote is, if this vote comes out 16-14, 17-13, anything below a 2/3 vote, then we know that the rest of the trial probably doesn't mean a whole lot, probably won't result in a removal.
Right. And it'll be more than one vote. They didn't say exactly how many motions they had.
Right.
But it's more than one.
Right.
And again, there was 14 or 15 motions the first day, right? I mean, it was a bunch.
There were at least 8, I think. So
it was quite a few. So it feels like there's going to be maybe a similar number because they were talking about grouping them. So I don't know. It's just really, I don't know. I'm struggling here.
And what they're doing, if someone is trying to figure out what's going on, the defense has moved to dismiss the articles of impeachment, and we're going to have an individual vote, or maybe not some combination of single and combined votes on the 16 articles of impeachment. It'll take a majority vote to dismiss any of the articles. That's 16 senators out of the 30 who are voting can dismiss the articles, and then that would mean that article was no longer under consideration. We have 16 different articles.
I could see some of the articles getting tossed.
Right.
It's very possible.
I think that's quite likely, actually, because I think there's some of the, there's some catch-all articles, some ones that are broader, based on broader conduct. Those would be the ones I'm really interested in. Okay, so somebody's asking what happened. Okay.
That's what I just tried to explain.
Yeah. Somebody's asking. I'm reading the comments. It was kind of a wild situation that we saw unfold, and we're all still kind of coming to grips with it. And I think the senators are also trying to come to grips with it.
Laura Olson headed out, didn't testify. Dan Patrick said she's not available. Rusty Hardin accidentally rested, and so Tony Busby of the defense has called for a vote on whether to continue the trial.
Yeah, and we're waiting to see what they're going to do. I guess they're reviewing the rules, and we're just kind of waiting to see how it's all going to shake out.
There was some question about these motions and which ones were not, the Senate was not allowed to debate, and which ones would be debated like a typical Senate floor debate, which ones would allow senators to argue. So, I'm sure that's gone into the discussion now of how, whether the senators will be allowed to debate and discuss in open Senate floor these articles, these motions.
We've certainly never seen anything like this before. Of course, what we're watching right now is we're looking at this live feed of the Senate chambers, and you see, actually we can see Busby, and there's Mitch Little, and I don't know if that's not Chris Hilton. Let me ask you this. We haven't talked about this while we're still kind of killing time here, Victor. Did you read? Have you followed the whole issue where 6 attorneys? Oh, okay, Ryan's walking over. It's okay. Go ahead.
A couple things. So, Texas Tribune reporter does say a Senate is about to vote, so it does sound like they could vote tonight. But also, Paxton has tweeted.
Oh, I talked about it.
Okay.
Yes.
Got it.
I talked about it. Now we're all over it.
So I don't
we
watch
talked
the
about it.
stream.
That's okay. See,
Yeah.
Ryan, you should watch the stream.
So the House and Ken Paxton's team have both filed arguments. This is, I'm reading from the Tribune, have both filed their arguments for and against tomorrow's motion on combining the vote. So we have what both teams feel about tomorrow's vote.
But
There is for those of you who missed that much earlier, there was a motion by the House prosecutors to combine the final vote at the end of the trial. They were set to have 2 votes, one on whether to remove the Attorney General, and then a second vote on whether to bar him from seeking future office. The House prosecutors moved this morning to combine those 2 in one vote so that they're not voting twice on that. But that can't be considered until tomorrow.
right. So Chance Escamilla asked, "Does the defense get closing arguments since they haven't rested?" Well, the way, can you kind of explain to folks what's going to happen next? With your
So
understanding?
give me the question again.
Does somebody's asking, does the defense get closing arguments if they haven't rested? I mean,
So the defense will not get closing arguments if the articles of impeachment are thrown out or dismissed. That will be the end of the case.
okay, so
But if the articles of impeachment stand, then we will move towards argument, and both sides will get argument.
okay, so we've got a live look there in the Senate. We can see Dan Patrick up on the dais. We've got, you can see Tony Busby up there, and the House impeachment managers listening to what Dan Patrick has to say. So we're finding out. You can see Dan Cogdell there, and I guess waiting to see what they've decided to do and how they're going to handle this.
And Ken Paxton is apparently on his way to Maine, and we don't know where Laura Olson is. So.
Well, I'm guessing Maine temperatures are probably a lot nicer than it is in Texas right now, although it's not as crazy hot as it has been. But I'm assuming we're gonna. There's Rusty Hardin. You can see, of course, Mitch Little. They're all up there talking at the bench. What do you think the conversation is, Victor?
Well, they're probably discussing the procedure for dealing with the pending motion to dismiss the articles of impeachment.
Well, you know, Dan Patrick looks like he's in a pretty good mood. So, interesting. We're just waiting to see what they're going to... I mean, are they going to wrap it up for the night, or are they going to do these votes? That's what we just don't know.
That's right.
It looks like
It's a stunning way to end the day, is all I can say.
all right, Natalie Haddad says the prosecution plans to file a counter motion. So we'll wait and see
Waiting on the
what
specifics.
that'll amount to.
Lots of motions and counter motions, but it's certainly not the way we thought this day was going to end. This is definitely the way we started and the way we're ending is not. Of course, you know this, Victor. In most trials, the moment you think you know what's going to happen,
You just don't know exactly.
But the perception is already that the House screwed up. I mean, that is the prevailing perception of the day, that they screwed up in not having Laura Olson scheduled earlier, that they screwed up in their timing, they screwed up in their handling of the clock, and now that they have screwed up in resting too early. I mean, there is a prevailing perception that for whatever you may feel about the articles in the case against Ken Paxton, that the prosecutors have not handled it in a effective way.
Right. And you have to wonder whether senators can use the cover of those errors to say, well, you just mismanaged the pursuit of the case, so I had to vote against the articles.
Mm-hmm.
well, and if they, I mean, I think that, a lot of people think that, and you said this, Bud, that pretty much most of them knew what they were going to do coming into it.
I think they all knew what they were going to do. They all had their minds up and their loyalties set. And like I've said, I did not think this would come to trial. I thought it was within one or two votes either way of 2/3. And I was surprised when it did go to trial. And I thought, well, wow, we're going to go ahead with this thing. And I thought the first couple of days that more senators were leaning toward the prosecution, but then they started kind of taking apart some of the young attorneys that had worked in the office, and and you had some effective Busby theatrics that really haven't had a response from the prosecution.
Yeah. Huh.
Of course, we got into this discussion of whether Rusty is really appealing more to the senators while Busby is appealing to the TV viewer. Whether Rusty's more effective with the senators making their case. But the senators have to go out and get votes from the TV viewers. The senators have to go out and campaign. The ones up in next year have to go out and campaign. 3 of the senators who are up next year are the ones who voted firmly with the defense every time. Tan Parker, who we mentioned, from Highland Park, Denton County, Paul Betancourt from Houston, Donna Campbell. They were all firmly on the side of the defense every time. The interesting case, Joan Huffman sided with the prosecution. She's on the ballot. And then 2 of the people from the Metroplex, Phil King from Weatherford and Fort Worth, and then Drew Springer from Munster and Northwest Texas. They're both on the ballot next year, and it will be interesting to see which way they vote in these votes. It does take more than 2 people swinging. It takes a 8 to 10 vote swing from the original vote to throw out the charges at this point. So it would take a huge swing in jury opinion, despite the prosecution's miscues, for the trial to just suddenly blow up in smoke right here.
Right.
So they just sent me a copy of the House Board of Managers' motion to reconsider Senate Rules 27 and 30A.
So that's the motion for tomorrow?
That's the motion for tomorrow. Yeah, that's the one where they're trying to combine the votes in terms of removal, and they're basically saying that it says these rules are inconsistent with the Texas Constitution and the purpose of impeachment, which requires that a state official who is convicted of committing impeachable offenses be both removed and disqualified from holding future office. I don't know. I mean, can they have? I mean, that's a constitutional question, I guess, right?
Right.
They can combine it. I mean, under the Constitution, the trial is to decide whether to remove and bar from future office. It was the committee that decided to hold separate votes. There's nothing in the Constitution that requires separate votes.
Okay, and then there's the motion. Okay, this is the response from Paxton's team. Okay, hold on. Okay, I'm catching up with these emails that are coming in, and they're basically saying it should be denied outright or deferred until after a vote on Attorney General Paxton's innocence. Regarding deferral, should the Senate vote to acquit the Attorney General later this week or early next, the acquittal will mute this late-breaking question raised by the House and will make any consideration of this motion unnecessary. Furthermore, as the House points out, every precedent weighs against this House's position. Modifying 100 years of precedent on the fly and at the last minute would not respect the gravity of that precedent or this process, and in any event, the House is wrong on the merits in their misreading of the Constitution, and it goes on. So they're just arguing back and forth about, I mean, presumably we're going to see a vote on it.
Absolutely, right.
In terms of deciding one way or the other, but there's going to be, I think what we're going to see is just a whole flurry of activity. Is this, I mean, I know this is not a criminal trial, but this is pretty kind of normal in trials, right? I mean, especially big trials.
Sitting around and waiting is something that happens when you have a complex trial with multiple participants.
And then somebody else has sent me this tweet showing that Ken Paxton is heading to Maine next week to sit down. We actually read that earlier, but he's going to talk to Tucker Carlson, and I guess he'll have his answer by the time he appears with Tucker Carlson in terms of how this is going to shake out. I think. Okay, so all right, we see Dan Patrick up on the dais. Looks like we're about to get started again. Is it? Let me pull up the Senate feed too.
I don't see the jury in their seats.
No, but it looks like we're kind of starting to head towards something, maybe. I don't know. It's just kind of interesting. We're trying to figure out, you can see Dan Patrick there talking to Lana Myers. Do you know Lana Myers, Victor?
I do. She's a very good member of the bar, very respected, former jurist and lawyer.
Justice Myers has worked really hard these last few days.
She has, and I think she's been, really helping, get Dan Patrick where he needed to be. And let me ask you this, Victor, how would you assess Dan Patrick overall today?
Well, what I will say to the point that we were just talking about with Lana Myers, having her alongside him gave him a great deal of credibility today, given her stature in the bar.
Have you ever argued a case in front of her?
I have not, but I have known her in professional circles, particularly the Dallas Bar, and other professional organizations I've been a part of, including assessing her qualifications, and just an outstanding lawyer in person.
Well, she's one of the few Dallas folks that's involved in this, because all the most of the attorneys that are, the big names in this are out of Houston.
That's right.
And she, like you said, she has a very good reputation among Dallas attorneys. And she was a former Dallas County District Judge, and then she sat on the 5th Court of Appeals, and she retired maybe within the last year or two.
Yes, she is. So it's really good to see her participating here, and like I said, she's adding a great deal of credibility to the administration of these proceedings by being alongside the Lieutenant Governor.
And of course, she was the Lieutenant Governor's second choice. He originally named Mark Brown, who was a former state appeals court judge in Harris County, and he was named to this role all in one day. And it was found that he had donated money to Eva Guzman in the campaign last year, and so he stepped down from this role because he had a campaign donation on his record. But Justice Myers apparently did not.
Okay.
Yeah, and so that's how she was a...
That's how somebody from Dallas sneaked in.
They occasionally let a Dallas
person in. We talk
in.
often on Inside Texas Politics about how Houston runs the whole state, that Greg Abbott was a judge in Houston, Dan Patrick's from Houston, Ted Cruz is from Houston, that all the power players are from Houston. And General Paxton was an exception, but that Houston really is the just kind of the cauldron of politics, and tends to elect the most colorful Republicans and Democrats that wind up moving into statewide office.
Well, you know, I technically grew up in the Houston area.
I was
Texas
born. I
City.
was born in Houston.
Oh, okay. So
Yeah,
we're like transplants up here.
That's right. We've been here since 1998.
Well, I left in the I moved away in the mid '90s to take the job in Abilene at the newspaper out there, and I always thought I would end up back down there. And you know, I moved to North Texas in 2000, and you know, here we are, 23 years later.
Well, things are calmer here.
They
so,
are calmer, but I don't know. I've covered a lot of crazy stories in Dallas over 20 some odd years. I mean, you know, just so many things have happened. But yeah, I guess it has been very much the battle of the battle of the Houston attorneys. These
Houston lawyers, everybody from Houston. I mean, Houston has all the reputation that goes back to Percy Foreman, who defended Jack Ruby for a while, and so many other cases of Patty Hearst. And so Percy Foreman's flamboyant courtroom style led to Racehorse Haynes, who was the defense lawyer for Cullen Davis, who, and so many other cases too in Houston. But and here he was known for defending Cullen Davis in 2 series of trials in Fort Worth, where despite eyewitness testimony identifying Cullen Davis, he was acquitted by a jury, both of first in the killing of a man at his former home, and then later in a murder for hire case involving a former judge that they convinced was staged and that he had no idea what was going on and that he was improperly charged. So Racehorse Haynes achieved the acquittals in both those with a great flamboyant style and a long series of colorful characters. Then that is what led to this round. I mean, the Racehorse Haynes, begat Tony Busby, and of course Dick DeGuerin came along, overlaps both generations.
Right.
And we haven't seen too much of Dick DeGuerin in this trial, but Dick DeGuerin overlaps both and has his own style. And then you have Busby comes along with this flamboyant, just this attack dog style that makes him famous. I mean, people call him the best trial lawyer in the country.
Well, and certainly the defense team has been more flamboyant between
Certainly,
Mitch
for
Little
sure.
and
Members,
there we
after
go.
council